Well, we should get going. I'm David Erdos. I'm Deputy Director of the Centre for Intellectual Property and Information Law here at Cambridge. You won't have seen me very much because I am on sabbatical leave, but it's my very great pleasure to introduce Graham Greenleaf, who is Professor of Privacy Law and Information at the University of New South Wales and has been visiting us for a month as a Herschel Smith Fellow, our first fellow on this programme in information law. So we're really, really pleased to have you, Graham. Thanks. And Graham has been in the field for several decades, I think, working away on...
You're too kind.
Particularly working away on Asian data privacy laws and also first generation instruments. So going right back to the 1970s and the 1980s, which was a very interesting and formative period in data protection and privacy law, very much understudied today, but Graham has been very much one of the people who has been bringing that to the fore and talking about it and integrating it back into the more contemporary literature. And his topic today, I can't think of anything better than to get the year off with looking at the whole 50 years, half a century of privacy laws, not only in Europe, which we often concentrate on, but across the globe. Seeing as this is a privacy law seminar, I should say something about our recording policy. We do tend with speaker consent to record the seminars, but we only put the lecture, not the following, well, anything that follows fully the lecture in terms of question and answers, we try and cut. But it enables us to get our message and get some of the research out there to a broader public. Without any further ado then, I will pass over to Graham.
Thank you, David. Well, thank you all for coming along this evening. It's nice to have an audience that is more than the customary 3 men and a dog, as we say. And this is, in fact, the end of my very productive and enjoyable month's stay here at Cambridge. I think tomorrow is my last day that I'm on the books, so it's nice to be finishing like this. And I want to thank CIPIL and the faculty very much for their hospitality. Particular thanks to David for the benefit I've had from his wonderful depth of data protection scholarship, which is certainly in some areas quite unrivalled, I think. And to Lionel as well for some very stimulating discussions about the relationship between intellectual property and privacy, which interests me a great deal as well. So as David said, I've sort of got a fairly big canvas for tonight's discussion. And it's always, of course, unwise to share one's first drafts of articles and that with any audience. People caution against it. And it borders on insanity to share your working notes before you've even got to a first draft of anything. So this presentation is very much in the under construction category, I'm sorry to inform you. But the topic is basically what I came here to spend a month looking at while I was at Cambridge. So I thought, no, I shouldn't talk about something that's sort of been in the can for years. It's better to talk about something that, at least in my mind, is still quite fresh. So this is about a project which will probably occupy me for some years to come. And the basis of it is confronting what do I have to do, what does anyone have to do, to try and make sense of the fact that we now have had 50 years of the development of data privacy laws. I think that the answer to that challenge lies to a significant extent in reconciling the increasingly ubiquitous data privacy laws that are found in countries all around the world with the many international instruments that have grown up over that same period of time. And as I see it at the project at the moment, and I'll try and outline tonight, this is the basis of what I'm going to talk about, is it involves 4 steps. First, I want to identify the principles that have emerged as data privacy principles over that 50 years, and I see them as falling into particular sets of principles, generations of principles, I call them, which have emerged sequentially over that period of time. And particular groups of those principles make up a standard in various uses of that word at particular times. Then, having done that, I want to locate all of the national data privacy laws around the world as to where they fit in relation to those generations of principles. And then thirdly, I want to need to assess the effective enforcement of those laws, because the second step involves just the laws on the books, as we say, the formal laws. The third step involves looking at the reality of those laws in action through their enforcement. And I take a particular theoretical approach which is based on the ideas of responsive regulation. I'll come to all that later. And then finally, it's necessary to try to assess whole privacy regimes, which is essentially the principles enacted in a particular country's legislation and all the enforcement mechanisms that go with it. And in order to do that sort of assessment, you need to take into account the objectives of data protection laws to come to an overall assessment. And times have changed since 1970, 50 years, and what we want to achieve out of data privacy laws has changed rather dramatically in those times as well, I'd suggest. So we're not going to be applying 1970 standards to an overall assessment of data privacy regimes. Oops. So the data privacy laws themselves. We have, as I've said, 50 years since the first of those laws in the state of Hessen in Germany. The Datenschutzgesetz, please excuse my non-existent German, but that's the title of the act from which the expression data protection comes. It's the first piece of legislation that's accepted as setting out data protection rules, and it created the first data protection authority, of which Professor Spiros Semitis was the Data Protection Commissioner. The first national law comes a couple of years later in Sweden, the Data Act in Sweden, and it was largely based around a registration system, but it also had a data protection authority. Fast forward to today, and on my criteria, we have 136 countries that have national data privacy laws. Since 2014, the majority of those laws have come from outside Europe, and as of now, only 20% of those laws, 28, not surprisingly, are from the EU. And while most laws are comprehensive, a few only cover either their public sector or private sectors. Set out graphically there in terms of the spread of laws across the world, and as you can see, they really are a global phenomenon. The different colours involve the peachy colours, countries that only get there because of their public sector law. The red ones only private sector law, blue ones are comprehensive. But there's a lot more going on than that. And on my count, there are 27 countries at present with official bills for new laws. the green ones that we see to a significant extent scattered across Africa and the Middle East, but also in Latin America, and although you can't see it because the map's not good enough, quite a few in the Caribbean and various other small places that don't quite register on this map. But there's more than that going on, because a significant number of countries that already have data privacy laws are in the process of enacting revisions of their laws. So, we see that Canada and Chile and Argentina and Australia and India and China and Kazakhstan, all of which have existing data privacy laws, are also in the process of revising them at the moment. So I think you could say that there is a global ferment of data protection legislation going on at the moment, more than we have previously seen. And in fact, over the last decade, there's been an average of 5.5 new laws each year, 5.5 new laws each year, whereas over the whole 50 years, or since 1973, the average has only been 2.9 new laws per year. So there's quite an acceleration of legislation in that sense. And it looks like this. By decade, 10 laws in the 70s, 10 more new ones in the 80s, 10 more there, a further 20 in the 90s, further 40 in the 2000s, and this decade there will be, by the time we finish this year, 60 more laws, including some, I think by then I'll have concluded that both Turkmenistan and Tajikistan have new laws, so they're coming from unlikely places. Right, now, in parallel with those national legislative developments, we have the development of international instruments of various sorts, of which I can count at least 16 as being of some significance since 1980. There were significant developments before 1980, but for various reasons I choose to start there. I won't go into the details of that. And all of them that are in italics are not enforceable in various ways. They're guidelines, or they don't yet have the necessary number of ratifications to come into force, like the African Union Convention, for example. But as you can see, there are instruments from Africa now, and there's a Data Protection Commissioner's standard from Latin America, drawn up at the request of all the Latin American governments. So, they are of significance at regional levels around the world. So, as I said, I think the task is how to make sense of the 136 plus laws, and the first step involves mapping their formal contents against the principles that arise from the international agreements. And I interpret those international agreements as establishing 3 generations of data privacy principles, and take those one particular set of principles together, and you can also call that a standard, what I've called a generation. And cumulatively, each successive generation includes the principles in the previous generation. So they don't completely eliminate each other, they are cumulative. Now, what's the purpose of this? I find 2 main purposes so far. That doing this mapping enables me to make one form, not the only form, but one form of rational comparison of national laws. I can ask how many of the international principles and from which generations does the law in country X include or embody. On the other hand, it gives me another form of assessing the extent to which particular principles from any particular generation have been adopted globally. And I can say that, well, I won't give examples now. I'll get bogged down if I do. So what are these generations of data privacy principles, it should really say, that I identify? There's no particular rocket science about this. They're based on the international instruments with which you are probably most familiar. I argue that it was not until 1980 when both the OECD established its guidelines of 1980 and the Council of Europe Convention 108, first version thereof, formally adopted in 1981, but developed at the same time and with a lot of overlap in discussions with the people developing the OECD guidelines. It was not until that point that there was anything you could call a global consensus coming out of the various inchoate developments of the 1970s. But with those two instruments, a minimum set of data privacy standards was agreed as the basis for allowing free flow of personal data between countries that were participants in those two sets of standards. So that's the first generation. But while those principles, as we'll get to in a minute, are pretty much universal now, and I'll explain what they are in a sec, we then have a second generation, which I would call the current global standards, as I'll explain, which are based primarily upon the EU Data Protection Directive of 1995, which in itself was partly based on some additional stronger principles in Convention 108 that didn't make it into the first generation, and then an additional protocol of Convention 108 in 2001 that effectively caught up to some extent with the directive, not completely, but to some extent. Then the third generation, no surprise, is based on the GDPR of 2016, in force since 2018, and also, in a complex way, the new version of Convention 108 called Convention 108 Plus, which overlaps with the majority of the innovations in the GDPR, but far from all of them. Now, previous slide had 16 international instruments on it. But as it turns out, I think only 6 of those, the 6 mentioned there, have been essential to the establishment of the generations of international standards. The other 9 of the 15 have in various and different ways reinforced those 3 standards. Some of them have only reinforced the first generation, that's the OECD APEC family. Others have reinforced the second generation and parts of the third generation. We look there at the Latin American and African instruments. But none of these other 10 of the 16 have contributed anything really additional to the international standards. Possible arguable exception about mandatory data breach notification and its early appearance in the revision of the OECD guidelines, but that's a detail. Right, turning now quickly to each of these three generations. Here's our first generation principles, and these are just what you'd expect in any data privacy law. Now that we're 40 years down the track from 1980, this is what you would expect in any data privacy law. And I've mapped there where they feature in the OECD guidelines and where they feature in Convention 108. But I should stress that Convention 108 had some additional principles as well that went beyond what was in the OECD guidelines. This is the minimal consensus. Now, I don't know when no one had done this, but in 2011, I put up a definition of what a data privacy law is, having failed to find one anywhere else. And this is what I came up with, that any independent legal jurisdiction, which for simplicity I've called a country, has a data privacy law if it has laws that cover the most important parts of its private sector or its public sector, or usually both, but in some cases only one or the other. And that it provides a set of basic data protection principles that approximate the 10 in the previous slide, and that they must include the individual participation principles, the right of access to your own file and the right to correct it, the concept of finality to some extent, the fact that uses and disclosures of personal data are limited by the purpose for which the data was originally collected. Not just limited to that, but limited by that, but with many, not exceptions, but many ways to make further use. That there must be a security principle, because otherwise all other principles are worthless. And I've said at least 2 of the other 4 principles, the remaining 4, must be included. So it doesn't require 10 out of 10, but you need most of those principles to say you have a data privacy law. And it also must have some methods of officially backed enforcement, not just self-regulation. Now, all of the 136 countries in the lists that I republish every year or two meet these criteria, and those criteria seem to have been widely accepted, probably given the absence of other contenders. But I'll stress again, this only requires a law on the books that says nothing about the extent to which a law is or is not effective. So the first generation of data privacy laws has effectively become the definition of a data privacy law. Now, moving to the second generation of data privacy laws, which we can also call European standards because they come out of 2 European instruments. They're all found in the directive of 1995. The first 3 were already in the original Convention 108. These 3 came from the additional protocol to Convention 108 of 2001, and these 4 in the middle never made it into the original Convention 108, but are now in Convention 108 Plus. And 25 years after the directive, there is no longer anything really surprising about those principles. They have become just once again, after this fluxion of time, what people would by and large expect in a data privacy law, although the definition of the legitimate basis of processing is still something that is controversial in many places in the world. But what I argue is they have become the global standard. And the evidence for that sort of goes along these lines. That, well, I'm not considering Europe in any detail because all 28 EU countries should have in their law what's in the directive. The additional 20 European parties of Convention 108 should have enacted at least the additional 6 principles that are found in the original Convention 108. And in 2011, I did an analysis of 33 of the 39 laws from outside Europe of countries that had data privacy laws, that is. And what I found was that those data privacy laws showed an average enactment of 7 out of 10 of the second generation principles. So there was a much stronger correlation between non-European laws and, we can effectively say, EU laws than anyone had previously expected, because no one had ever bothered looking before. And I did a further, more limited study in 2017 because it's difficult to replicate this study because the number of countries is so much larger. And which showed, I just looked at the top 20 countries by GDP outside Europe that had a data privacy law, and I found a fairly similar result of 6.5 out of 10 second generation principles enacted. So my, I think, quite reasonable hypothesis is, particularly with all of the stronger laws now being enacted, the current global standard for data privacy laws, you could describe it at least as most of the second generation principles. No, this current standard is not the entirety of the directive, but it's most of the directive is found throughout the world now. And it's getting stronger. So global data privacy laws have been largely Europeanised. And out of that 2011 study, there was some quite interesting specific results concerning specific principles. At least 75% of those 33 countries assessed in 2011 included these second generation principles, which are some of the stronger ones. So it was quite a strong implementation of European principles, even at that stage. And for other reasons, I've looked at the Asian laws this year, so 2019 figures here, and found that the average implementation across Asia was 6.1 out of 10 of those principles, even with countries like China and Bhutan now included. This is still almost certainly less than the global average outside Europe. And the reason is that I think this is the reason, that Asian countries on average are less influenced by France, Spain and Portugal than is the case with the countries or a large number of the countries in Africa and all of the countries in Latin America. And France, Spain and Portugal are very strong proponents, very active ones, of concerning European data privacy standards. So, moving from there to the third generation principles, of which I think the innovative aspects of the GDPR, there are about 18 elements that I identify, but this is still all open to argument about what are the significant new elements in the GDPR. You can have lots of interesting discussions about that. But where I've settled on at the moment is that these 10 are in common between the GDPR and Convention 108+. the modified or modernised Convention 108 that was finalised last year. Then you have in the GDPR a further 8 what I would think of as significant principles, and certainly some of them are among the most talked about, that are not found in Convention 108 plus. So it seems to make sense to me to try and analyse the influence of these third generation of principles in two halves, as it were, to see if it makes any difference, whether it's something that's shared with Convention 108 or not. Right. And here is just some initial, fairly rough examples of countries in Asia and in Africa. I've been working with a colleague from Switzerland who's a francophone, and therefore I can figure out with his assistance about a lot of the African laws that I wouldn't otherwise be able to deal with. But the enactment, you see on that screen, of the principles held in common between the GDPR and Convention 108 plus, I've found in those two regions 57 examples so far of those principles being enacted, and I know David would add a couple more in Asia, in the right to erasure and the right to be forgotten. And as I say, there's plenty of room for interesting discussions. Then the ones that are in the GDPR only, a further 37. So 94 instances so far of principles in those two regions. And I'm intending to do similar analyses for the other regions of the Middle East, Latin America, so on. Well, where we get to is there, for such an early stage, only 18 months after the GDPR came into force, there's already a very significant level of enactment outside Europe, even on the limited areas that I've looked at. And there's already very significant variance in terms of which principles are enacted in quite a few countries and which principles are enacted hardly at all. So the only example where I found the only one where I found no examples so far is proportionality required in all aspects of processing. There's no clear instance of that anywhere. Very popular examples are data breach notification to data protection authorities, 9 instances of that, and data breach notification to data subjects, 9 instances of that. But there are lots of other principles that have 6 or 7 examples so far. So a lot of variability. I best move. I'm taking too long. How do we interpret this? Well, it's all very well to establish various levels of isomorphism or similarity, but that doesn't necessarily imply causation at all. So cautious interpretation of what such similarity means is necessary. It's often argued that there can be 3 types of, or it's commonly argued there can be 3 types of such interpretation. You could have isomorphism that is, in a sense, coercive. You won't get a particular benefit unless you do this. So you won't get free flow of information between Japan and the EU unless you meet the EU's standard of adequacy. That's a sort of coercive reason for isomorphism. And it doesn't mean that those standards have been adopted out of any normative commitment at all. And in fact, in the Japanese case, they were not adopted, some of them out of any commitment, as evidenced by the fact that the Japan was only willing to amend its law so that particular principles would only apply to data that came from Europe, sourced in Europe, in effect, data affecting Europeans. And they wouldn't apply the same principles to personal data concerning Japanese people that was sourced in Japan. So there was clearly no normative commitment to that. On the other hand, you have countries where ministers, when introducing bills, say the GDPR is the gold standard for enactment of data privacy laws in the world, and we want to have a high quality law, therefore we're adopting not all the principles that are in the GDPR, but a lot of them. And that happens quite a bit. And David pointed out to me that there's also mimetic isomorphism, a habit of cut and paste. And I don't know enough about the politics of Benin, but they adopted almost every single thing in the GDPR in Benin's revision of its data privacy law. So I don't know if that was out of deep-seated principled affection for privacy or something else. It's a complicated picture. But those reasons are not enough anyway, because there can, of course, be independent creation, separate from any of those, due to similar causes. So if similar technological changes and social changes lead a country to conclude we must have a law that does this, then even if they dress it up with the similar wording to other laws, that's not necessarily the reason. Those other laws are not necessarily the reason. There can also be indirect coercion, and this is quite important in this area, in the sense that countries may be adopting a particular principle because a regional standard that they are committed to requires them to do so, but that regional standard is also based upon, say, the GDPR or the directive. And so indirectly the coercive effect of benefits flows down from these original standards. And there's much more that can be said about comparative law scholarship on transplants and the like, but time does not permit. So I want to fairly quickly go through just the last couple of steps in this argument. As I said, we'll be talking about the law on the books, but you must then assess the effectiveness of the enforcement of laws. I found when writing this book about Asian data privacy laws, where I was only looking at 14 countries with full-fledged data privacy laws, that the approach of responsive regulation theory was quite applicable to data privacy. And the elements being the requirement of multiple levels of sanctions of escalating seriousness, so it's an enforcement pyramid. Sanctions at the top get used less than the cheaper sanctions at the bottom. That for there to be responsive regulation, not only must the sanctions be actually used when necessary, because the whole thing falls over if they're not. The big stick has to be used as well, but it must also be used visibly. That the use of each level of sanctions must be visible both to those who are regulated and to the consumers who benefit from regulation, and in particular the legal and other representatives of both. So that some form of tariff for particular breaches of particular principles emerges, and if you want to argue it this way, a market for privacy compliance develops. And so, the higher levels and their actual use and their visibility become incentives for the lower levels to be made to work and for a sort of broader-based regulation to be effective. There's also much more to be said about that and other factors such as the resources available to a data protection authority are important in determining how effective regulation is. Okay, getting to my final step, the evaluation of whole privacy regimes, both the principles on the books and the effectiveness of enforcement. Well, if we're now looking at 2020 is where our perspective is from now, we have a different environment completely from 1970. In relation to the private sector, primarily, as Shoshana Zuboff has argued at more length, and I think more convincingly than others, we are in the age of surveillance capitalism, in particular where personalised marketing has created a completely different privacy environment. And as Edward Snowden showed us half a dozen years ago, state surveillance of private sector data is far more pervasive than anyone expected. And if you put surveillance capitalism and state surveillance together, then you do, as they will inevitably be together, then you have a surveillance environment that is totally different from that in previous generations. Now, what I then argue is that our overall assessment of privacy regimes can only be against our expectations of what these data protection regimes or individual parts of them actually do or could do or should achieve. And that will vary between individuals as to what they expect this aspect of law to achieve. Now, my own approach is to say that you can assess this type of overall effectiveness against purpose at three different levels. You can say data privacy laws are there to remedy unintended injustices of information systems, and this was the argument in the 1970s and 80s. James Rule and his colleagues in 1984 roundly criticised that as the efficiency criteria for assessing data privacy laws, because it did nothing to stop surveillance multiplying and expanding. All it did was make it operate in a way that was somewhat fairer but would not impede its extension. So going on from Rule's critique, you could say that limiting expansions of surveillance systems is another goal, another level of expectation, that you want data privacy laws to stop the expansion of surveillance systems where they are inconsistent with the data privacy principles currently adopted. Or you can go further than that, which I would now advocate, and say that you want data privacy laws to play their part, not to play the whole part, but to play a part in reversing already excessive surveillance, whether by surveillance capitalism or state surveillance, on the basis of rejecting the underlying business, social and political models on which those surveillance systems are based. Now, data privacy laws are not going to completely turn surveillance capitalism back in its tracks. However, there's a lot of things that they can do to stop certain undesirable aspects of surveillance capitalism from working and to turn it back to a position from where it is now. But to do that, they'll require the assistance in particular of anti-competition laws. And all over the world, competition regulators are now regarding abuse of the dominant position of platforms in relation to personal information as anti-competitive conduct in itself. And so they are becoming allies with data protection authorities and together. I'm an optimist. I think there can be a reversal of surveillance capitalism. State surveillance, I'm not so sure. And I think that's... So my assessment of these principles is, do they contribute to this goal? I had here, I'll just leave it up on screen, some comparisons of why things are now so much worse and so much more difficult than they were 50 years ago. But anyway, I won't go through that. But we are in a different era. That's just the simple point. And it's only when you look at it over the whole 50 years you see how different it is. If you look at it from the perspective of 1995, in the middle there, oh, well, it's very different, but, a lot of these things were starting then. They were not starting 50 years ago. Thank you. I'll stop.